She walked into that courtroom like the proceeding was a formality, like the outcome had already been determined by the thickness of the legal team her father had assembled, and the confidence that comes from never having been in a room where money could not solve the problem in front of you. She sat down at the defendant's table with the particular ease of someone who had been told by everyone around her for her entire life that rooms like this one were ultimately manageable. That every room was ultimately manageable if you knew the right people and had retained the right representation and understood that the law, like most things, bends toward those who can afford to keep bending it. The senator had a different understanding of what was about to happen in that room. He had been preparing for this proceeding for 11 weeks. Not in the general way that lawyers prepare for proceedings. In the specific way that someone prepares when they have obtained documents that the other side does not know they have and has spent considerable time constructing the exact sequence in which those documents will be introduced for maximum effect. He had reviewed the financial records 3 times. He had cross-referenced the communications against the timeline twice. He had identified the single transaction that connected everything else and had built the entire architecture of his argument around the moment when that transaction would be named out loud in a room where it could not be denied. She did not know about the transaction. That was the thing she did not know that she did not know. Her legal team had been thorough. They had anticipated most of the lines of attack that a proceeding like this one might produce. They had prepared her for questions about the company, about the decisions made in the years before the investigation began, about her role in those decisions and the degree to which her role made her personally liable for what the company had done or failed to do. What they had not prepared her for was the document that the senator had obtained through a channel that her father's legal team had not anticipated being used. A channel that had produced a single page showing a transfer, a specific transfer, a transfer made at a specific moment in the sequence of events that her side had been arguing she had no knowledge of. The opening of the proceeding was unremarkable. Procedural language, introductions, the formal establishment of what was before the court and why. She sat through it with the composed impatience of someone waiting for a meeting they consider beneath them to conclude so they can return to the things that actually matter. The senator watched her sit through it. He noted the composure. He noted the impatience underneath it. And he noted the specific moment when she glanced at her lead attorney with an expression that said she believed this was going exactly as expected. It was not going as expected. He began his opening with a question that seemed routine enough that she did not register it as the beginning of something larger. He asked her to confirm her role in the company during the period in question. She confirmed it through her attorney with the minimal precision of someone providing information they consider irrelevant. He asked her to confirm the dates of that role. She confirmed them. He asked her to confirm that during those dates, all financial decisions above a certain threshold required her direct approval. Her attorney objected to the framing. The objection was noted and partially sustained. But the question had been asked in a way that put the general shape of the answer into the room regardless of the ruling. She looked at the senator for the first time with something other than impatience. It was brief, a flicker of reassessment that lasted less than 2 seconds before her expression returned to its default composure. But it was there, and the senator had been watching for it. The first document he introduced was not the transaction. It was a communication, an internal message from the period in question that referenced a decision being escalated for approval. The communication did not name her directly. It used a title, her title, during the period when she held that title. Her attorney moved to contextualize the document immediately, argued that the use of a title rather than a name created ambiguity about who specifically had been involved in the decision being referenced. The senator acknowledged the ambiguity, said he understood why the defense would want to focus on it, and then introduced the second document, which was a follow-up communication from 3 days later that used not a title, but a name, her name, attached to an approval. For the specific decision the first communication had been escalating, she shifted in her seat. It was small enough that most people in the room did not notice it. The senator noticed it. Her father noticed it from the gallery where he had been. Sitting with the stiff composure of a man accustomed to controlling outcomes who was beginning to sense that this particular outcome was not behaving the way outcomes were supposed to behave when you had spent the kind of money he had spent on the people sitting at that table. The senator moved through the next 20 minutes methodically, each document building on the previous one, each introduction narrowing the space available for the argument that she had not known what was happening, that her role had been nominal, that the decisions being made below her had not required the kind of oversight that would have made her responsible for their consequences. By the time he reached the 15th document, the space for that argument had become very small. She was leaning forward. The composed impatience had been replaced by something harder and less managed. She was writing notes and passing them to her attorney with a frequency that suggested the notes contained instructions rather than questions. Her attorney was absorbing those instructions with the practiced calm of someone who had represented difficult clients in difficult situations and understood that the most important part of their job in this moment was to prevent the person next to them from making the proceeding worse than it already was. Then the senator introduced the transaction document. He did not build to it. He did not signal that it was different from the documents that had preceded it. He introduced it in the same methodical tone he had been using for the previous 40 minutes, named the document, named its origin, named the date it was produced, and then described what it showed. What it showed was a transfer. A specific amount moved between two accounts at a specific moment in the sequence of events, a moment that the defense had been arguing she had no involvement in. A moment that her own testimony in a prior deposition had described as one where she had been deliberately removed from the decision-making process at her own request. The transfer showed her signature, not a title, not an approval through an intermediary. Her signature on the authorization line of a document moving an amount large enough that its significance was immediately clear to everyone in the room who understood what they were looking at. She looked at the document. She looked at her attorney. Her attorney was looking at the document with an expression that told her everything she needed to know about whether this was something that could be managed. It was not an expression that suggested it could be managed. What happened next took approximately 4 seconds and will be in the record of that proceeding for as long as the record exists. She turned from her attorney to the senator. The senator was looking at the document he had just introduced. He was not looking at her. He was giving the court time to absorb what the document showed. She looked at him for 2 seconds with an expression that had moved entirely beyond the composure she had walked into that room wearing. And then she raised her hand, and she extended one finger, and she held it there long enough that there was no ambiguity about what she was doing or who she was doing it to. The room did not process it immediately. There is always a fractional delay between a thing happening and a room full of people registering that the thing has happened. In that fractional delay, the courtroom was still the courtroom it had been for the preceding 2 hours. Procedural, formal, governed by the architecture of legal process that had been holding everything in its proper place. Then the delay ended. The bailiff moved first. Her attorney grabbed her arm simultaneously. Her father was on his feet in the gallery before the bailiff had taken 3 steps. The senator looked up from the document. He looked at her. He looked at the raised finger. He looked at the court, and he said nothing. Because he did not need to say anything, because what she had just done had said everything that the remaining documents in his file would have taken another hour to establish. She had just demonstrated in 4 seconds, and with one gesture, what 11 weeks of preparation and 15 documents had been building toward. That she believed she was untouchable. That she had walked into that room with the conviction that its processes did not apply to her the way they applied to other people. That the signature on the transaction document and the finger raised at the senator came from the same place, the same understanding of how the world worked and where she stood in it. The court called for order with a sharpness that cleared the room of every sound except the gavel. Her attorney was speaking to her in a voice too low to be heard from the gallery, but visible in its urgency from every seat in the chamber. Her father had been asked to sit down by the person next to him, and had complied with the particular rigidity of a man containing something.